is a quarter mile away, you're saying is only, say, 5%. How can that be? The answer is this, that it's 15% for the entire property, but we are recognizing that in the far corners, the furthest distance, it may be 0. But as you get closer and closer to the line, the damage issue goes up and up and up. That's the reason.
The right-of-way itself, the 150-foot wide right-of-way, is one measurement, and then just the proximity is another one?
Yeah, the way it's done in our state is there are 2 value losses that an appraiser estimates. One is called loss, the other is called damage. Loss is the actual loss of a property right. On an easement, that is the easement area as it's defined, 150 feet by, say, 880 feet long. That defined easement is the loss of real estate rights. That's one value. The second value is, once an appraiser has established that, then they ask themselves, is there a loss to the remainder lands, that being anything outside of the easement? Is there any loss of value whatsoever? If there is, that's called damage. It's damage to the whole property. Both of those put together is your total compensation. That's how it's done in the state of Wisconsin. Yes?
For instance, if this line were across a property through woodlands, those woodlands would have to be clear cut according to what they say down the way there. So does that mean they would pay for the loss of the timber as well as the easement?
Yes. There are several ways an appraiser can do this. The state of Wisconsin has the rule in eminent domain. The appraiser is always to select appraisal methodology that benefits the property owner, not the condemned owner, which would be ATC. So whichever method will benefit you. If, for instance, the wooded area is mercantile timber, which would be a higher value than, say, just wooded area, then the mercantile timber is valued independently, then the land, all right? But when you value the land, you're valuing it as non-timbered land. You can't double up on this. If we discover, for instance, that wooded land takes 20% more than non-wooded land in this area, we could look at it 2 different ways. The 20%, let's say it's 2 acres, the 20% difference extra because it's wooded, or the mercantile timber, whichever gives the highest of the 2. That's the route we'll take. So yes, you are. And you do have the right to the mercantile timber. You also have the right, if it's not mercantile, for them to cut it and set it aside, and you can utilize it later for your own purposes and still get paid for it.
So this is a one-time payment that you get,
One time.
but it's an ongoing cost, though.
Yes, here's a problem. Okay, you're dealing with a forested land. It's a pre-planted forest land. The trees are immature, right? They're going to mature in 5 years or 6 years. That's where you get the peak price, except they're taking them now. Because they're immature, the mercantile timber is very little. Maybe you're better off just selling it off at that point as wood for the fireplace or for the furnace. But at 5 or 8 or 10 years from now, that value will be extremely high. That's a real issue, and that issue has not been resolved. Again, you cannot get paid on a prospective value in the future. It's market value today and how that's defined. Yes?
What if your house is in the easement right now?
Right now?
Well, if it proposed easement.
First of all, I consider that extraordinary unusual. Of all that, I've done about 300 plus, maybe even 400 appraisals in this whole area. I've never seen once a house in an easement area. So I consider that extraordinary unusual. If that is true, there are 2 potential issues involved here. One is obviously the impact to the house. Now we have to also have an electrical engineer come in and look at what the potential is going to be to all the electrical in your house, all the metal and all of that. There is a potential that your house may end up having a negative value. That is a potential. We have one case, and it's actually, I'm not sure if, don't cite me on this one, but it's called Waller versus ATC, Waller, W-A-L-L-E-R. This case has gone to the appellate court. I'm not sure if they decided on it yet. I know the attorney, and the attorney's Hugh Brown. And Hugh Brown has already stated that he'll go to the Supreme Court on this one. It's an extremely unusual case, and it's a case where the easement on a residential property became so overwhelming, not touching the residents, but so overwhelming in its presence that the highest and best use changed from residential to linkage with the nearby property and raising the house. The unusualness of that case is both the ATC appraiser and Waller, I was their appraiser, actually agreed on that, which is an amazing thing. We actually did agree on that, and the big question became relocation. That case is right now sitting in the appellate court under relocation issues, and ATC is fighting the issue of relocation because of its potential of what it could be in a situation such as yours. Okay.
Well, what about unforeseen damages either during construction of the power line or after, for instance, erosion during or fencing, or your cows start getting sick after the fact?
Okay.
Is that identified by the contract or not?
Some of that is civil action, such as your cows. That would end up being a civil action. That would not be under the realm of eminent domain. Eminent domain, however, is going to take all of this in consideration. If your property, highest and best use is farming for animal husbandry, dairy, let's just make that assumption, and the power lines are in very close proximity, the appraiser has to look at other properties like yours when the power line is in close proximity, and how did that impact the buying behavior? All right, you have stray voltage issues, you have the potential issue of the EMFs onto the cows, things of this sort, which may be real or they may be not real. It doesn't matter to the appraiser. What matters, it doesn't matter if it's a scientific fact, what matters is, does the buying public believe it? If they do, and they act on that belief, that's a fact. And that's why it was mentioned earlier, EMFs. I will never go into court and argue EMFs devalue property value. Why not?